Hi, this is David Merlin. Welcome to a Code Breaker video. What I'm going to do today is review for you the status of two cases on the appellate level where the exchange of briefs is complete. Let me begin by edifying you to the fact that nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis, believe it. You're going to see a load of proof of that. This is tax litigation, and I'm starting with the homepage of the Kentucky capital offense criminal complaint for an indictment of a man who has on record a good faith misunderstanding of the law. So you recognize this from the Kentucky criminal complaint video. And we're going to, the only reason I have this up here is to touch on the flow of the law concerning how to calculate your cost when all you've done is sell your services for compensation. Now, it's October 20th, 2017. As you'll see, these briefs exchanged on appeals between the known universe's best tax attorneys, the ones who know and have mastered all things tax law, against little old 11th Circuit litigant who has the brief. Basically, it's identical to the issues raised on the 9th Circuit. Both cases are finished to date, October 20th, 2017. The courts have not rendered their decisions on the 9th and 11th Circuits. So these are two tax court cases, one out of Miami, one out of Seattle. Both appealed to the circuit court level, raising new issues, claiming miscarriage of justice, fundamental error on the lower level, because you aren't allowed to raise tax law issues in tax court if it relates to the particular statutes we're going to look at. And so you have to save it for appeal. And we'll see if the appellate courts even allow it. We get one opening brief, then the government files its opening brief, and then we, the citizen, we file our rebuttal. And then it's over on appeal. There's no discovery, no back and forth about evidence and witnesses and the rest of the good garbage you get with a civil case. And we'll see what the courts do. They might procedurally screw the case to where the appeal to the Supreme Court really concerns more of a procedural issue than it does anything else, which is fine. It's still just a paper war. But what I wanted to show you was the comparison between two videos that you have to have watched. This tutorial is predicated upon your knowledge of the Key to the Code video and the Section 83 tutorial that's 2.5 hours long. Take both of those courses, those tutorials. Those two issues were waged for the first time on appeal, with docket numbers that prove you can't raise these issues in tax court. So it's a fundamental error, miscarriage of justice. And you'll see the particular provisions relied upon, the ones that are key, the ones that really swing the axe, if you will. And then you'll see the government's reply. And they fail. And then you'll see the reply to that by the citizen. And then you'll see a motion to dismiss in Kentucky U.S. District Court where the government asks to dismiss a civil counterclaim filed by a man that the government sued. He counterclaimed him, demanding a clear explanation of the laws. If you're going to take my real estate, I want a clear explanation of the laws. You promised that to me in Taxpayers' Bill of Rights. The Supreme Court said I have a right to it in Helvering versus Texpen Oil Company, 1937. The taxpayers are entitled to know the basis in law and fact upon which the commissioner sought to sustain the deficiencies. What is so hard to grasp about that? How did Section 83 operate in your conclusion I owe a tax on my paycheck? Do you have a chapter of the tax code that identifies citizens of the United States as a subject to an income tax? You'll watch them fall on their faces in this exchange of briefs that just occurred on the 11th Circuit. We're waiting for the 9th and 11th Circuits to wipe themselves with a law which will allow us to petition the Supreme Court with the appropriate question, whatever that might turn out to be. So here I have the Kentucky criminal complaint, and again, the only reason I wanted to show you this was to touch very quickly on the Section 83 equation. Very quickly, I can summarize that easily for you. This is the Kentucky law nexus to federal law, especially this one. Gross income means gross income is defined in the Internal Revenue Code. Great, I got you right here. Internal Revenue Code 61B. For items specifically included in gross income, see Section 71 through 90. Section 83 is right in the middle of that. And look at all of the great authorities. You can pause this if you need to read it. Look at all the great authorities that say Section 83 explains how to tax your pay. It applies to all of it. It's omnipresent. It is ubiquitous. It governs the taxation of compensation for services. You can't get away from it. If it screws you, you're screwed. But if it protects you, do you want those protections? I'd like to know the government's complying with the law. Otherwise, it's kind of like taxation without representation, where the law, the legislature, our representatives are taken out of the loop. I don't need anything like that. So let's keep the law in the loop so we can keep our representation intact regarding taxation. That's the difference here. I either have access to the law, or the government can just run any scheme it wants and not have to worry about being held to the letter of the law, which is taxation without representation. It's not taxation at all if it breaks the law. It's extortion and racketeering. Period. So now we know Section 83, as I said, is all over. It explains how to tax you. And if you pictured the tax code sitting on a table across the room and you're next to an IRS agent, you go to the tax code and you go to Section 83A. They go to the tax code and they go to 61A. And that's the difference. And yet we have the IRS Chief Counsel right up here. I'm scrolling back. IRS Chief Counsel. IRS. Section 83 provides for the determination of what is to be included in gross income. Not the IRS, Section 83. So you don't go to 61A. That's where they win. Everything is taxable. Well, Section 83 tells you what you're allowed to place in 61A. Well, we can't talk about that. We'll penalize you for asking. That's tax court. So here I have 83A, and only the excess of the value of my paycheck over the amount paid is gross income. And they restate that in this tax court case, Pagel Incorporated versus Commissioner. Section 83A generally provides that where property is transferred in connection with the performance of past, present, or future services, the excess of the value of the property or my compensation over the amount paid for the property is includable in gross income. That much of it's correct. They really throw a lot of crap into the sentence, but the meat shines through. Shiny meat. You heard it here first. Now, I get into Section 83, only the excess over the amount paid. What's the amount paid? I need to know that before I know what the excess is. Here's the definition of it: the value of any money or property. There's another way to figure your cost or amount paid. Go to 1.83-4B2 and it says the cost, the basis, the cost of the property in the hands of the transferee, that's me, I receive compensation, shall be determined under Section 1012. First regulation under 1012, your cost is the amount paid for such property or your paycheck or your fee, commission, tips, whatever you got, self-employed or employee, in cash or other property. It doesn't exclude labor. And neither does this one, any money or property. Where's your authority to exclude labor from cost when the law says all property is cost? The cost under 1012 is also known as adjusted basis. The adjusted basis is the cost or other basis prescribed by 1012. So we look for that word adjusted. All this does is assign a synonym. And 1.1001-1A does the same thing that this does. 1.83-3G, that's the definition of income. The amount paid refers to the value of any money or property paid. Your cost is the value of any property that you gave up for your paycheck. We know what remains is the gain. And so here we just had the cost separated from profit. By the language of Section 83, only the excess of the value of my paycheck over the amount paid. Exactly, that's the definition of income, and we see it again right here. The fair market value of property is a question of fact, but only in rare and extraordinary circumstances will property be considered to have no fair market value. The section 1001 contemplates that from the amount realized upon the sale or exchange, there shall be withdrawn a sum sufficient to restore the adjusted basis prescribed by Section 1011, which is the cost prescribed by Section 1012, which is the cost under Section 83 according to 1.83-4B2, and the regulations thereunder. The amount which remains after the adjusted basis has been restored to the taxpayer constitutes the realized gain. The amount which remains after the cost has been restored to the person who performed the services constitutes the profit. There's the definition of income in a statute that has to apply to you. Nobody has a choice. As I said, if it screws me, I'm screwed. But if it protects me, I want those protections. All property is a cost. Here's the annotation on all property is a cost. The value of property is determined through the terms of an arm's length transaction. You've seen this in my work before. I don't need to go through this again. The definition or the treatment of the term any when you encounter it in law, it is all inclusive. Here's 5 Supreme Court cases that say so, that the government won. And here's 4 tons, 2 oceans approximately of appellate case law that concurs with those Supreme Court cases. That any is all-inclusive unless the law provides for an exception, and they can't come up with a law that provides them latitude to accept labor from the definition of cost. And here's the IRS in Publication 17 for 23 years telling you that your services are your cost. Here's the Taxpayers' Bill of Rights. You're entitled to clear explanation of the laws. Kentucky, no you're not, as we'll see. So here I have the Section 83 equation. Now this is the Melton decision. While unpublished, it's the opinion of 3 judges. It's a Fourth Circuit decision, and 3 judges say the tax is imposed by clear language, and I don't see them refer for 1 second to Section 83 or 1001, 11, and 12. This is how the government figures your taxes. They deprive you of Section 83, 1001, 11, and 12 to steal your money by depriving you of the standard for calculating cost embedded in the language of statute and regulation. Checkmate. So now I have the amended opening brief from the 11th Circuit. Filed a great big one with 700 plus pages of evidence, because there's new issues on appeal. Got to file evidence in support of the brand new issues, right? And did the same thing on the Ninth Circuit. And on the Ninth Circuit, they called in like 7 or 8 fire trucks. No, they added 4 attorneys to the case. Excuse me, but you've had these issues since 1994, right? And you need 4 more attorneys. Is that right? Okay. So, a blessing in this appellate duty assignment that I took on. The client said, I'll make the table of contents and the table of authorities for you. I need the practice. Right on, man. It's neat to have somebody stepping up to do the clerk work. And so more power to them. That's great. Because, as you look at this, it's a document that requires refinement. So he says, I'll do it. Great, thanks. Table of contents and exhibits on appeal. I'll review those in just a second. You'll see on the left I got bookmarks here. And we'll get to exhibits in just a second. Table of authorities. And all the cases cited. And Microsoft Word did this table of authorities. So any grades you pass out, please keep that in mind, as well as the fact that this client likely had made precious few table of authorities in the past and had only a couple of examples to follow. Yeah, I don't expect excellence. I want the thing on the docket. Let's go now. Engage. And that's what I'm after. That's what he's after. So everything's just fine. This is swell. And all I had to do is write the briefing. And a document such as this is impossible to proof. You are your own worst proofreader, so I delegate. And, 3 or 4 people go over one of these documents, and it shoves it back on the drafter of the document as an incumbent responsibility to be exact first time through, no typos. So you just can't get a perfect legal document unless you're going to pay proofreaders that that can look through a keyhole with both eyes. And anyway, here's an example, formatting. So no big deal. Here we are, exhibits on appeal. Right here, bingo, exhibits on appeal, Exhibit A. The tax court petition that he had filed, which had arguments not raised in this appeal. Because you can't raise these arguments in tax court, they'll penalize you. Number 2, IRS's frivolous argument list from 2013 that does not contain these arguments. Publication 17 excerpts that say your services are your cost. Appendix B. Appellees, that's the United States. The United States' opposition to the Section 83 claim filed in 2008 in Alaska. This case is not on the LexisNexis database that I could find. And even the unpublished cases are on the LexisNexis database. I couldn't find this when I looked for it. The next one, Exhibit 5, the U.S.'s opposition to the 1.1-1 claim in the 2008 case. Hey, you said these answers over there in those cases in 2008. How come you're saying something different today? That's why those are in there. Exhibit 6, U.S. District Court's concurring opinion in that case. Saying, yeah, based on their briefs, sure. Send them to prison. It was a criminal case. And in response to the 1.1-1 argument, they said, oh, he's claiming to be a non-resident alien, Your Honor. You've heard me talk about this in the previous videos. So yeah, I want to have that in there. Exhibit number 7, U.S. District Court's order in U.S. versus Iran. A totally different response, but from the court. U.S. District Court Chief Judge Robert A. Rant wrote a decision against the briefing of the 1.1-1 claim. And then we have the tax court petition filed in Orth versus Commissioner in Indiana, because in Exhibit 9, when the IRS answered that petition, they said, that's correct. We agree with the 1996 Talmadge versus Commissioner decision about Section 83. It's the only time they've explained on the record why the argument against Section 83 is mistaken. They said you didn't buy your labor before you sold it. And so everything you received when you sold it is a profit. But the law says any money or property is a cost. And they say, except labor. But they don't have a law that allows them to. And they just double down on the Talmadge decision from 1996, which makes it a 2016 refreshed standard, brand new. Today, that's the standard still. And they can't come up with a law that allows them to exclude it from the from what is to be considered cost. Checkmate. Checkmate. Standard of review. The Administrative Procedures Act case law says, yeah, that's what you're supposed to get in tax court. And in their reply, they argue against it. It's amazing. Just amazing. Statement of the issues. This is about tax court. The first one. This is Rowley versus Commissioner. Hey, the logical force requiring rejection of their arguments apart from their assertions of personal political philosophy, which do not provide a basis for us, a court sitting to interpret the law, to decide the questions dispositive of this case. And so they penalized them. And 1 year later, in Abrams versus Commissioner, the pleadings do not raise a genuine issue of material fact respecting respondents' determination, but rather involve only issues at law, and so will penalize them. So in 1 year, we sit to decide issues at law, and they didn't ask us to do it, so we penalize them. The next year, someone asked us to decide issues at law, so we penalize them. You know what that sounds like? Oh, no. I'm not saying I'm better than you. No, I'm saying the opposite. I'm saying you're not as good as me. See, you have your filthy, nasty perversions, and I have my opinion of your filthy, nasty perversions. That's what they just did here. They went on judicial holiday. You got to have this 1 year? Oh, you did it the next year? Well, we're going to penalize you for that too. And here are the docket numbers from the 90s of people that filed briefings of Section 83 and other issues, and they were penalized thousands of dollars for arguing statute. So, the issues, here they are, summarized. You don't need the briefings on these. You got them in previous videos. As a citizen of the United States, I'm only named in Treasury Regulation 1.1-1 when the 16th Amendment says Congress can collect this tax. It has to be a statute. And so your deficiency is null and void. You don't have a statute, a chapter of the tax code that applies to me. Issue B. You're in violation of Section 83A in your determination that I owe an income tax on the value of my labor. This is the first time on appeal tax court did not get these issues. Issue C. It's not imposed by clear language, either because of they can't answer the statute or misleading statements by the IRS. The deficiency at issue is void, and amounts in controversy cannot be collected without a violation of appellant's right to due process, the void for vagueness doctrine. A and B. Meaning, they told me for 23 years it was my cost. Regulation tells me all property is cost, and here I am under advice from the government in regulation even, contrary to what the court's going to decide. And the tax isn't imposed by clear language. Lenity means lenience. Where the construction of a tax law is doubtful, the doubt is to be resolved in favor of whom upon which the tax is sought to be laid. And the last issue, I'm going to lose my rights to a passport unless I get on a payment plan with the government if my controversy is over $50,000 and they have a lien or levy in place. But I haven't gotten review. And you're going to see in the appellate brief, they didn't get to a lot of these statutes that are at the heart of these issues. Didn't even mention them. And yet, I'm going to lose my passport when you can't even get me review of key statutes that I pinned my entire modus operandi on? Everything I did was because I thought it was lawful, and now you're going to stone me? That's what that says. This paragraph, new issues on appeal. The fundamental error or miscarriage of justice on the level below me violated my rights to due process, Your Honor. And it's an exception to the bar against new issues being raised on appeal. Another exception to this rule is when new issues are purely legal in nature, constitutional, statutory, or relating to legal doctrines. And there's our annotation. Okay? Brief of the issues. Let's see. Now, I just want to show you some key provisions so that when we look at the government's response, we see how sparse it really is as it relates to a logical defense against the assault on Social Security and the overall statutory scheme at 26 U.S.C. that was made in the this opening brief. This is about Social Security. You say that I've underpaid Chapter 1. It's not about Chapter 2. It's not about Chapter 21. It's not about Chapter 23. Those are Social Security, and I'm obviously not that citizen, and I'm obviously not the citizen that's eligible for benefits. And that goes all the way back to Section 211 of the 1935 Social Security Act. Period. So now we have Chapter 1, Section 1, and to identify the subject of the tax imposed thereunder, they wrote a regulation saying citizens of the United States owe this tax. You can't do that with a regulation. So I'm keying upon 1.1-1 and Section 1. And I've got a Seventh Circuit decision that says outright 1.1-1 is the IRS regulation identifying those persons who are subject. Well, statute has to do that, doesn't it? U.S. District Court, First Circuit, tax regulations of the United States generally provide. Well, it has to be a statute. And so, don't bother me with it. Until you have a statute, and I've got an appellate case that says it's not a statute. The people in that case didn't have the wherewithal to stop right there and say, hold it, it's only a regulation. And they got sandbagged. So, a citizen is defined by the regulations. Why isn't it defined by a statute? They can't talk about it. Now, in U.S. versus Arant, Seattle, 2008, the judge pointed toward decisions relating to assessment authority. Well, that would lead one to believe, and this was Chief Judge Robert S. Lasnik, it would lead one to believe that unless there's an assessment, there's no income tax owed, but there's plenty of case law that says otherwise. So why are you citing as proof my argument's wrong case law relating to assessment authority as proof they have authority to impose a tax? Imposing a tax and assessing a tax are two entirely different things. So, I'm not Chapter 2, 21, and 23. Chapter 1 is what I am, you say, and that's not me. Watch for these provisions when we look at the reply brief from the government. Another formatting error. This bounced back and forth between us several times. And we're doing our best. Really, it's commendable that someone else would be willing to even handle a document like this. So this, from that angle, has been a very enjoyable project, that I got people far enough into their case to where they're actually, let me do that. I'll do that for you. Let me copy and paste this brief, whatever. And they did the trimmings on this document. Now, we know Section 1 of the tax code does not mention citizenship of any nature, but the regulation does. And this is the Supreme Court, 1957. In light of the above question, we cannot but regard this Treasury regulation as no more than an attempted addition to the statute of something which is not there. As such, the regulation can furnish no sustenance to the statute. Seeing also Seventh Circuit, where, citing Calamaro, the Seventh Circuit added, it is a basic principle of statutory construction that courts have no right to first to determine the legislative intent of a statute and then, under the guise of its interpretation, proceed to either add words or to eliminate other words from the statute's language. Similarly, the Secretary has no power to change the language of the revenue statutes because he thinks Congress may have overlooked something. Exactly. B. You deprive me of Section 83, and we know already 61B and Section 1001, 11, and 12. Okay? And we'll see how many of those they mentioned in their reply brief. And I get back into the equation. As you can see, the same thing I did in Kentucky. Same deal. Now, let's go to, here's the Talmadge excerpt in Orth versus Commissioner, 2016, Indiana Tax Court. They said, yeah, this is the standard, because he quoted this in his petition. And they said, right, this is one. We agree with this case and its findings. This is tax court. Since he paid nothing for his labor, his cost, and thus his basis, is zero. Well, the law says any property is a cost. And they say, no, he paid nothing for his labor. And you say, but the law says any. And they say, okay, we're penalizing you thousands of dollars. That's precisely the dead end to which this argument has led. This impasse. Not a dead end. We're in court. We're going to the Supreme Court in two cases in, as soon as the 9th and 11th circuits are done. This video is done just in advance of them rendering their decisions. They're overdue. I think it'll be soon. I know it should be soon. Now, tax court, 1996. In attempting to equate his wages with property for which he has a cost, well, only because the law says so, petitioner's argument is nothing more than a variation. It's Congress. It's the law. If you're violating it, you're stealing. You lose your job, 26 U.S.C. 7214, and if convicted, you go to prison, 26 U.S.C. 7214. It's not just a variation. It's the difference between handcuffs and the next paycheck. Petitioner's argument is nothing more than a variation of the wages are not income claim frequently advanced by tax protesters. Show me one other tax protester. And there, I just made a concession. I called myself one. Show me one other tax protester that's made this argument. They don't cite any other cases here, do they? So, you don't have a cost in your labor. He appealed to the Fourth Circuit. And this was the decision, and then he got a cancerous tumor on his neck, and his Supreme Court case was thwarted due to that, a medical emergency. So the Fourth Circuit said, based on tax court, oh yeah. And they let stand the $6,500 penalty imposed on Stephen Talmadge for, quote, I will concede all facts of the case today if they'll just tell me how to comply with Section 83. And here's the government, let's see, the IRS's answer to Orth's petition. Okay? It was included in the evidence here. Now, Section 83 equation, here's the end of it. We come down to Section 1001. The adjusted basis has to be restored to the taxpayer. And taxpayer's Bill of Rights, here we are. It's, you have the right to know the clear explanations of the laws. The Melton excerpt, we don't consider Section 83. That's very telling. Issue C, it has to be imposed by clear language or we win. And they say, oh no, in Kentucky you'll see they even argue against this standard that you see for the tax has to be imposed by clear language. It's a bunch of Supreme Court cases, and they argue against it. Watch. Right here. The tax must be imposed by clear language. These are Supreme Court cases. They were thrown right in the faces of those attorneys and the court. And the attorneys, in their motion to dismiss the counterclaim, which sued only for clear explanations, he argues that it's a tax protester argument. The Supreme Court is a tax protester. It's something else. And I'm going to be deprived of my passport privileges when they can't even debate the law. And here we are on the Supreme Court level here. The appellate court, we're going to lose. And so, all the way to the Supreme Court, and the record is barren of proof that Section 83 has operated, Section 1012, 1.83-3G, 1.83-4B2, or no indulgence of the question as to whether or not 1.1-1 deviates from Section 1, when Section 1 doesn't even mention anybody's citizenship. We're not going to get review of those. So by raising these for the first time on appeal, we put the government up against the wall. We will not have review, and so it's really going to the Supreme Court on a due process issue, saying tax law is a secret. The record's barren of evidence that a tax is imposed for these reasons, and frame the questions correctly in light of the decisions rendered on the 11th and 9th Circuits. And then it's a matter of whether or not the Supreme Court will take it while the law remains a secret. Here is the government's response brief. No oral argument is requested, or really we don't believe it'll be necessary. And you're right, it's just about the law. In fact, why bother? We know what's going to happen. They know what's going to happen. Big deal. And look how similar this table of contents is to the one that the client made for his case. That's great. Now, arguments. Much is made. Taxpayers cannot challenge their underlying liabilities for the income tax of these years. That's 18 years ago? Who keeps their records for 18 years? Taxpayers had prior opportunities to contest the existence and amount of the underlying liabilities. It doesn't matter. Supreme Court said the tax must be imposed by clear language. They didn't say, unless you failed to raise it at a lower level. I have rights to the law every time I go to court. Because if you're breaking the law, I want you arrested. And so the law is always fair game. I'd never let them tell me this. I'd always challenge them as unconstitutional, because still a clear explanation of the law is not on the record. My rights to due process are violated, however it is you got me here. I never waived rights to due process. I'm entitled to a clear explanation. Taxpayers' appellate arguments are frivolous. Get to the part where you can disprove them. The proposed levy and lien were appropriate because taxpayers did not propose a collection alternative. Well, you get to the part where you're not stealing. This is such a toilet. The government makes the practice of law a toilet, where if you're not a mouse, you're blacklisted as an attorney that's willing to take on a case of someone the government's up against. It's that easy. I've seen it, and I've seen it, and I've seen it. So here's their table of authorities. Whoopie-doo. Hold on. Table of authorities. I don't see. Section 212. Section 212 is a general catch-all that says, in the case of an individual, there shall be allowed as a deduction all ordinary and necessary expenses paid or incurred in the production or collection of income. The petitioner, the appellant, has claimed he's been deprived of the provisions of Section 83, 212, 1001, 11, and 12. They don't even mention 1012 because they can't get to the definition of cost. 212 only applies to costs and the individual who can deduct them. So they don't get to 212. But more conspicuously, 1.83-4B2 said to figure the cost of the property to which Section 83 applies, apply Section 1012 and the regulations thereunder. They didn't even mention Section 1012 in their brief, and it governs cost. In a nation of laws, that would be a victory for us. But we all know differently. And the client asks me at one point, he's looking over the brief and he's going, geez, you're clubbing them. You got Supreme Court cases at every turn. How do they get around this? And I said, anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. You're looking right into the face of it. They won't even have to have argued Section 1012, 1011, and 1001. And they're going to win because the law doesn't count in America. No Section 1012. Correct. No 1.83-4B2. They mention 1.83-3G, but they don't cite the language that says your cost is the value of any money or property. Well, why not? Because that leads to all the case law that says any is all-inclusive. And they didn't mention 1.83-4, which has the regulation that says you got to go consider Section 1012, and they didn't do that either. There's a whole half of the equation they left out of their rebuttal brief. Statement of jurisdiction, statement of the issues. We're always right, they're always wrong, Your Honor. Come on, what does the law matter, right? Standard of review, summary of argument. I'm serious. This is a toilet. Taxpayers brought this case to challenge the IRS determination to proceed with collection of taxpayers' unpaid income tax liabilities. For ancient times, the Stone Age, the tax court determined that because taxpayers previously had an opportunity to challenge those liabilities, their challenges to the existence or amount of those liabilities were barred. Taxpayers having failed to raise any issues other than a single challenge to liability, the tax court upheld the proposed collections. Well, we can't raise any other challenges in tax court. A taxpayer is considered to have had such an opportunity to challenge if he received a notice of deficiency or was offered a conference regarding the liability. Okay. So, get to the part where you're not stealing. They never even get to that. Tax court correctly upheld the proposed collection actions. Oh, sure. All this about we were right and they can't challenge us now. They had prior opportunities. Plenty of discussion about we shouldn't be forced to talk about the law, instead of pointing to docket numbers where the argument's been defeated before. They just have that one, and they point to it. Great, thanks. Not in this document, but in tax court in Indiana. Great. Get to the language of the provisions relied upon. Oh, can't do that. Something else. The appellate arguments are frivolous. Is that right? In their opening brief, taxpayers challenged their underlying liabilities for ancient times in income tax by making 4 tax defier arguments. Admittedly, for the first time on appeal, taxpayers did not raise these arguments before the Office of Appeals or Tax Court because they would have been penalized. Consequently, they are precluded from raising them for the first time on appeal. Generally, an appellate court will not consider a legal issue or theory raised for the first time on appeal. The miscarriage of justice or fundamental error is an exception to that, and I got docket numbers to prove you'll be penalized. So, these are from the annotation that you saw from his opening brief. That there are the 3 exceptions: constitutional, statutory, and legal standard. So anyway, taxpayers contend that they can make arguments for the first time on appeal to this court if the issues that they raise are purely legal or involve fundamental errors and miscarriage of justice, just like the Supreme Court said. Yeah, just like that. That's what he contends. Far from involving a miscarriage of justice or any serious legal issue, taxpayers' arguments are frivolous. Oh, is that right? That's why you can't mention the statutes that are key to it, that everybody says explain how to tax me. In any event, the arguments are frivolous and meritless. Taxpayers argue first that the U.S. citizens are not subject to the income tax. He said that the statute, there's no statute imposing the tax. He did it with regulation. It was much more specific than that. Second, they specifically argue that all property is a cost. Second, they essentially argue that wages are not income. Man, that's so they can lump you in with all the Patriot Movement cases from time immemorial. Third, they contend that Section 1, imposing the tax and the rate set forth therein, is void for vagueness. No. The contention is that the scheme is void for vagueness when you can't even give clear explanation of the laws that explain how to tax us or that you say apply to Americans. Fourth, in reliance on the first 3 arguments, they challenge the power to revoke the passport privileges. Further, relying solely on these arguments on appeal, taxpayers have waived the only argument that they made to the Office of Appeals and the Tax Court. Oh, they're tightening it up. Now that they've only raised these arguments, they've waived rights to raise all the other arguments that they actually raised before this. Oh, okay. Thanks, servant breath. Can't even talk about my provisions. Can't prove you're in compliance with the law, and you're just really quick to sew it up on me. Wow. That argument was to the effect that the IRS's computer systems are faulty. That's what he argued in appellate level, administratively with the IRS. Taxpayers first contend that they're not subject to the income tax because it does not appear in Section 1, and then they argue that, oh, he's an individual, and Section 1 mentions the individual. Well, the employee in Chapter 21 is an individual also, and you don't tax him under Chapter 1 because he's a Puerto Rican. 21, citizens of possessions. Section 3121E says so. You see how they just made an end run right around the law. I'm saying I'm not subject to the tax because statute does not name me as a subject if I'm a citizen of the United States. It's a very particular challenge they've had for many, many years. So he is an individual. Nobody can deny that. Okay. Taxpayers do not and indeed cannot deny that they are individuals. 1.1-1 merely specifies the individual is already subject. Specifies? A regulation can't do that. And in fact, it does not do that. But to say that it's allowed to do that is a dereliction. In any event, it is well established that U.S. citizens are, in other words, I'm done with my argument. I've given you 2 teaspoons of commentary, and I'm done with my argument. In any event, I'm done with my argument. It's well established, blah, 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 citing tax protester arguments that had nothing to do with this challenge. Taxpayers' second contention is a variation of the shop warrant argument that wasn't supported by statute. This is a toilet. These people believe their job is to steal from you. It's just a variation on arguments that didn't include this statute. It's Congress. Section 83, Section 1012. Oh, it's just a variation on the theory that the tax movement had. No, it's not. They said wages are not income. I'm saying all property is cost. You deprive me of Section 83. Totally different. Section 61A of the Code defines gross income as all income, including compensation for services. It's a general income. 61B says for items specifically included in gross income, go see Section 71 through 90. Section 83 complements 61. No, it doesn't. It governs whether or not you're allowed to even say Section 61. The IRS General Counsel, Section 83, provides for the determination of what is to be included in gross income. Section 83 does not complement Section 61. It governs 61 as it might relate to something paid to somebody in relation to services. Oh, man. Just a toilet. You get into this and you realize at the other end is somebody that takes an oath to uphold the law and the Constitution, and they get into litigation and reveal through what they're willing to say to you that their mission is to steal you blind to where your kids are diet deficient. In a nutshell, no. In a statute, in a regulation. This is an escape hatch. In a nutshell, Your Honor, these people are idiots. They can't get to the language of the provisions relied upon. Look for 1012 in this dissertation here. In a nutshell, a taxpayer must include in the gross income the fair market value of the property received. No, you include in gross income only the excess over the amount paid. Oh, minus the amount that she paid therefore in money or other property. Yeah. How come this isn't first? They put it second. They said first you must include in gross income what you received, then minus what you received. Really? How about if we just keep what we received and never include it in gross income unless it's an excess? They're running around the law with every sentence. Taxpayers' argument that they can deduct the value of their labor from their compensation, leaving no net taxable income, repeatedly has been rejected. That's not what the claim is. The claim is that all property is a cost. They can't talk about it. Right here, they generalize and drag you into a bunch of tax protester cases that didn't argue Section 83. And so the evidence was totally different. It's like the first time I went to prison on a murder charge, Your Honor, we didn't have DNA testing. Now we do have DNA testing. And they say, we don't care. You still go to prison. You still lose your property. The law doesn't matter. And they're proud of it. They're allowed to breed. We're all going to die. Greasy, slimy molesters that take an oath to uphold the law, running from the law with every sentence to screw somebody out of stuff that they say was earned 15 years ago? Who keeps their records for 15 years? Back to the moral and ethical bankruptcy of an attorney that's willing to do this. and they expect you to pay for the sickness of the evidence of their sickness, their spawn, to go to school, to eat. You support their families, and this is their mission. It's a toilet. Third, the taxpayers contend that it follows that the income tax is void for vagueness. A statutory scheme is unconstitutionally vague when a person of ordinary intelligence cannot understand what the scheme requires. Very good. As already explained, Section 83 is not only clear, you didn't even mention 1.83-3G or 1.83-4B2. What's so clear about it when you can't even talk about it? Didn't mention Section 1012. What's so clear about it? You can't even talk about it. As the tax court cautioned in reading, excuse me, but wasn't that the case cited when they penalized those people for raising issues at law? According to a derelict tax court case, tax defier arguments like ours are efforts to embroil the courts and the commissioner in a game of semantics regarding the definition of term, not the operation of terms. Not the definition of the terms. The operation of the terms which have a very clear definition. There. They avoided a specificity by going to a generalization. We're not talking about the definitions of terms. We're talking about the language of regulations that define the terms. The operation of those definitions. Taxpayers' fourth argument, it's not really worth even discussing. They know you can't get review on the lower level. Oh, man. It's just, they'll penalize you. So here I have, let's see, our liens and levies were lawful, and the conclusion, and that smell. Accordingly, give us their firstborn male child, Your Honor. I'm proud of my work. I'm David A. Hubbard, Acting Assistant Attorney General. Signing for me is Jennifer N. Rubin. Jennifer M. Rubin. Excuse me. Bridget M. Rowan. Attorneys for the Tax Division, Department of Justice. And they're proud to steal from you. Can you look your parents in the eye? So here's his reply brief. Reply point by point, paragraph by paragraph. And I'm not going to stop on every point here. Let's just do this. You can go ahead and pause. Read the paragraph. And I just take them on, going point by point to say that, get to the point. Hello? They will impose penalties. Here's your proof. There is no review at lower levels. Now they say on this level, it is imposed by clear language that we can't even talk about. It's amazing. So the reply brief reminds them of all this great stuff. And listen, this is key. The United States, the appellee, points to no case where it was held that this regulation does not deviate from Section 1. Even though the regulation contains jargon about citizenship when the statute doesn't. We're looking for that decision right there. They're quick to slander you. Oh, it's frivolous. Look, he's just look, the meager citizen breath has his meager little claim, Your Honor. Ha ha. And yet, they can't get to it. Where is the case where you've decided this? I got all the docket numbers in the world to prove you've had this every opportunity to disprove this claim. Well, that's nothing we're going to talk about. And so we're going to the Supreme Court while the record is barren of evidence that they're willing to even discuss the law. The individual in Section 1 can easily I'd like to buy a vowel. The individual in Section 1 can just as easily be the citizen in 1402B who is to use Chapter 1 provisions to calculate his tax, according to this regulation that says to figure this Chapter 2 tax, apply the same provisions that you use to figure Sections 1 and 3 tax. Okay, I can do that. Regulation can't deviate from statute. The 61B contention. They say 61A. 61A, except as otherwise provided. It's the first thing the statute says. Otherwise provided is 61B. 61B requires that you go to Section 71 and following. And when you do that, you find Section 83. The taxing scheme is vague. The Internal Revenue Code cannot be so read, for each section is not a self-contained whole, but rather a building block of a complex interrelated statute. Correct. 83, 212, 1001, and 12 are the foundational building blocks. And they leave them out. Let's see here. This is a quote from the Ninth Circuit case that we're waiting for an opinion in. Okay? So both cases. Main point regarding Section 83. The government makes no mention, government makes a mention of governing provisions, but abstains from facing the language relevant to its claim that appellant owes an income tax on compensation for services actually performed. Where is Section 80 or 1.83-3G, 1.1012-1A? Can we please get into the language of the governing provisions? No, we can't. Make the point again. While Appellate disembowels all foes in the Supreme Court with the argument that any means all, it asks of this court that it ignore those victories and abandon its own precedent to create a safe harbor by holding that any does not mean everything, that the 83 precedents are mistaken, and that property within which one has no basis is magically excluded from 1.83-3G and 1.1012-1A by some unspoken and all-telling departure from clear language which rules the day. Appellee doesn't even argue Section 1012 to rebut the appellant. This is the difference between having no gross income in the standard paycheck or fee and having received nothing but gross income. And it's determined by an unspoken found only in case law standard, a mere prudential rule, meaning court-created rule, that is not, and this is not due process. And the conclusion. I'm not going to read all this to you. You're welcome. Go ahead and pause. Pause again. Pause again. Appellant is entitled to absolution of the debts now held against him. And they can't talk about it. This is one level below the Supreme Court. And look at how precious little he's gotten in the way of review. Other people, they've been to tax court. Look at all the hell that's been raised in tax court over these issues. All those docket numbers. And they still don't have a clear explanation they can hand out like a party favor saying, oh, it's that kind of a citizen breath. Here's the disproving, or here's the proof your argument's faulty. They still don't have that. And they've had these arguments for how long? Motion to dismiss the counterclaim in Kentucky. Well, what's he suing for? Claim number 1, he has a right to access the law, but he's being deprived of this right by the fact they refuse to get into the law. And here's his relief. First cause of action, 3.2. Relief requested in paragraph 3.3. Okay? As an agency action that is unlawfully withheld or unreasonably delayed, plaintiff requests that this court compel agency action to establish and disclose clear explanation of the laws, every statute and regulation in a manner and form compliant with the requirements of the Freedom of Information Act, meaning I need it in a form I can discover under the law. Such explanations must include responsible reflection upon any and all statutes and regulations the IRS or taxpayer has to observe or otherwise apply to the instance of the taxpayer. Every statute and regulation. You'll never get that. Okay, claim number 2 then. If you can't have that, let's go to claim number 2. As an agency action, everything's the same except, let's see, clear explanations, plaintiff's subject provisions. Just the provisions I'm relying upon. I want clear explanations to those if you can't give me number 1. Okay. What else? Well, if you can't give me either of those, then it's obviously not imposed by clear language, and I want you to invalidate the assessments at issue, because they can't prove that they're valid assessments. And you can go ahead and pause this if you want to read that. When defendant fails in this way to disclose the operation of the law under the second cause of action, it's clear the defendant has failed to put his finger on the law permitting the tax man to put his finger on the citizen. And the Supreme Court said in 2001, United Dominion Industries Incorporated, something like that, that when the tax man seeks to put his finger on the citizen, he must also put his finger on the law permitting it. Well, if they can't do that, then I want the assessments invalidated. When the defendant fails in this way, plaintiff requests that the court hold that the Anti-Injunction Act is irrelevant because it bars you from maintaining an action in court to prevent the collection of a tax. It's irrelevant because no tax has been identified. That's a good question. And here's what they argue to keep him from getting just the clear explanations. It's something else. No bookmarks for this one. Okay. Finally, Steele claims that because the United States has violated his right to clear explanations of the laws, he has a right to absolution. No. He's saying that the Supreme Court says you're entitled to clear explanations of the laws. And that if it's not imposed by clear language, which would pretty much be evidenced by a failure to provide clear explanations, then I get a victory. They argue against it. Finally, he claims that they violated his right to clear explanations and he has a right to absolution of any tax debt when construction of the law is doubtful. We saw the Supreme Court cases that say so. These tax defier arguments that have long been rebutted, or these are tax defier arguments that have long been rebutted by federal courts. The Supreme Court said so. And they call it a tax protester argument. You're going to lose against criminals like this. The United States now requests this court dismiss the counterclaim for lack of subject matter jurisdiction because the Anti-Injunction Act and the Declaratory Judgment Act say he's not entitled to what he's asking for. Well, Anti-Injunction Act, he's just suing for clear explanations. The Anti-Injunction Act says you can't sue to restrain the collection of taxes. How come a clear explanation would prevent you from getting my money? That's a really good question. It springs out of this. And I told everybody in advance, here's where we're going to catch them. They're going to say Anti-Injunction Act. How come a clear explanation of the law would prevent you from getting my money? That's a good question. Servant breath. The counterclaim requests that this court compel the United States to issue explanations for every statute and regulation. No, his second one said, well, just the provisions relied upon then. The United States' failure to do so, he claims, renders his tax liability invalid. Yeah, I have rights to access the law. You can't put your finger on the law permitting it. And the Supreme Court says, I win. Steele's claim thus seeks declaratory relief, which Steele seeks to use as a restraint from collecting his tax liabilities. No, he's not. The Supreme Court said if it's not clear language, you win. They didn't say it has to be through a declaratory judgment. It's due process. They're referring to the Declaratory Judgments Act 28 U.S.C. 2201 and 2202 because there's a bunch of case law that says you can't use that for tax law or tax cases. The Act itself says so. Well, I'm not suing under the Declaratory Judgments Act. I'm suing under the Fifth Amendment. If it's not clear language, it's dismissed. The Supreme Court didn't say, unless Congress bars your right to the judgment. The Anti-injunction Act bars any suit having the purpose of restraining the assessment or collection of any tax. But we can't prove it's a tax. They jump right over statute to get to this word, tax. This language could scarcely be more explicit. Well, how come the language in the Supreme Court cases that we refer to is not explicit? It's a tax-defier argument to say, oh, if it's not clear language, I win, when the Supreme Court says it is. The purpose of the statute is to protect the government's ability to collect its stream of revenue, illegal or otherwise. They can't prove it's a tax, and they just go on and on about their right to screw you out of your property. It's not worth reading. They're arguing against providing clear explanations. In other words, respect to federal taxes means restraining the assessment or collection of any tax. How did Section 83 operate in your conclusion it's a tax? We can't talk about it. Okay. Let's see. The Administrative Procedures Act case law says tax court is governed by it. Failure to state a claim. And here they cite cases from the Sixth Circuit that say you're not entitled to clear explanations. So, where are you going to go, folks? His arguments are frivolous. Claims such as those in his counterclaim have been struck down by the court as shop-worn arguments. His counterclaim is that I want clear explanations. It's been struck down by the courts forever. Wrong. Shop-worn arguments. It wasn't an argument. I want clear explanations of those laws. That's not an argument. Such causes of action have also resulted in criminal convictions. Oh, is that right? Is that right? Such causes of action. Listen to this. Claims such as those made by Steele in his counterclaim have been struck down by the court as shop-worn arguments characteristic of tax protester rhetoric that have been universally rejected by this and other courts. Such causes of action have also resulted in criminal convictions, civil fraud penalties, penalties for frivolous tax court petitions, and sanctions for frivolous appeals. You barbaric bastards! You could go to prison for that. We could penalize you thousands of dollars for that because you asked for clear explanations of the laws. Is that right? The counterclaim is virtually free of factual allegations to support Steele's spurious legal conclusions. Well, virtually free of factual allegations. He filed several hundred pages of evidence as an offer of proof, and it's not about the facts. It's about the fact that government has no clear explanation of the laws they're required to comply with. That's the only fact I need to sue for clear explanations. And even if he had asserted these necessary factual allegations, federal courts have repeatedly held his claim that the United States' failure to explain the Internal Revenue Code warrants the absolution of his tax liabilities to be frivolous, lacking any plausibility. See the Sixth Circuit, 2009. You don't have a right to access the law. It's frivolous. It's not plausible to ask for clear explanations of the law. How come you promised it to us in the Taxpayers' Bill of Rights? Servant breath? A citizen's right to petition the government does not guarantee a response to the petition or the right to compel government officials to act on or adopt a citizen's views. Don't adopt my views. Show me how your view is correct and mine is wrong. It's the law. I can't pronounce that last name. Ehrmantraut versus Commissioner, 1985, denying a taxpayer's claim of an alleged violation of the Privacy Act. We didn't say that either. No provision of the Internal Revenue Code nor any federal statute or federal court has ever required the United States to explain the laws requiring United States citizens to pay federal income taxes. Well, it's about time they did so. I think it's a due process right. That's what I think. And I hereby allege that it's a due process right. And I will have it. For instance, in Boggs, the case they just cited here, Boggs versus somebody. Hang on. Boggs versus Commissioner, 2009. You can't have it. Taxpayers filed a federal income tax return claiming a large deduction on the return for human capital or a human machine, along with a memorandum. Well, this argument here is about tax code section 83. So it's not about that, is it? So don't bother us. The law, servant breath. The taxpayers then appealed the tax court's decision, claiming the IRS's failure to respond to their memorandum prevented the IRS from asserting a tax deficiency. It certainly prevents them in the real world from saying you owe a tax when they can't put the finger on the law permitting it. Like the Supreme Court requires, United Dominion Incorporated, 2001. The Sixth Circuit also rejected this claim as frivolous, holding the Commissioner has no obligation to respond to inquiries regarding the tax code. Horse shit. No obligation to respond. Inquiry regarding the tax code. Okay, I'm not going to inquire about the tax code. I'm going to look at publication 17 that says for 23 years my services are my cost, and I'm going to act upon it. And then they're going to penalize me thousands of dollars. These are child molesters on their best day. You're not entitled to a clear explanation of the court, or of the law. Sixth Circuit. And in the response brief, the Sixth Circuit, is that the same Sixth Circuit that said in U.S. versus David Lanier, or Lanier versus U.S. to the Supreme Court? I think it was U.S. versus Lanier, 1997. Is that the same Sixth Circuit that said it's legal for judges to rape women in their chambers? That's Sixth Circuit? So, yeah, right back in their faces over this. Because Steele's claims have been universally rejected as groundless and frivolous by a number of federal courts that we can't find, because they didn't cite any court cases that said because Section 83 operates this way, because we know that the answer is Talmadge versus Commissioner, 1996, doubled down on in 2016 in Indiana in tax court, and they don't cite Talmadge. Why? Why don't they cite Talmadge? They did in October of last year in tax court in Indiana. It's because Talmadge doesn't cite a law that allows them to make an exception for labor when you say any property is a cost. That's why. Steele's counterclaim relies upon tax defier arguments, all of which have been we've been here already. Show me the cases. We can't point to one of them that says 1.1-1 does not deviate from Section 1. You can go ahead and read this. This is the reply brief from the motion to dismiss in U.S. District Court. Thus, a federal income tax is imposed by statute. And Steele's claim that the United States cannot put its finger on the law fails. Section 1012. In the counter brief, this is the motion to dismiss, he was not nice. I got a client here that said, let it fly. And so we collected scrotums for coin purses in the reply brief. And he's going to lose. They will not supply clear explanations of the laws. But now he is a defendant, he is a taxpayer who can say, I even sued them for clear explanations of the laws, and they kept the law secret from me. Hands down, he's got the documents to prove it now. That's somebody the government still does not have the balls to indict because they will lose. A trial jury still will not let you send someone to prison who is on record with a good faith misunderstanding of the law. So, what he's done here might at best constitute a hedge against a criminal indictment in the future, but they're going to take him to the cleaners. It's what they do. So anyway, here's the motion to dismiss. In fact, the Anti-injunction Act provides due process in allowing taxpayers to challenge tax assessments prior to paying the liability by going to tax court. You can't challenge them in tax court. They'll penalize you. And so their argument fails across the board. I got the docket numbers to prove it. They were submitted as evidence by this defendant in this civil case before he filed his counterclaim. And the government just looks past it and throws crap at him. Steele's counterclaim raises the same or similar tax protester arguments he has already asserted in numerous motions. Wrong. First time he raised Section 83. And it wasn't raised as an argument. It was raised as proof that I need clear explanations of the laws. They won't give it to me because I think the law says this, and they disagree, but they won't disclose their interpretation. So read this and weep that an individual so depraved is allowed to breed in your country. And show me where they get down to the argument. Does Section 1 deviate, or does 1.1-1 deviate from Section 1, or doesn't it? The court's going to have to do the job. Where's your authority to exclude labor from any money or property? It's up to the court, and the court will find a way because every judge is as corrupt as the day is long. Isn't that easy? So they're proud of this work. They can't get enough of this work. And David A. Hubbard, this is in the Kentucky case. Where have I heard that name before? David A. Hubbard, response brief in the 11th Circuit. Oh, there he is again on the 11th Circuit. So in Kentucky, which is the 6th Circuit, we got David Hubbard proudly displaying his colors. What color is a child molester? Anybody? Hard to tell. And they're proud to put their name on this. How do you get this far from the law, folks? Time. They've been in office so long, they think this is the job to do. Instead of doing a job for you, they do a number upon you. And the law is therefore a toilet. And it's disgusting. Every time I have to write a reply brief against the government, when I have to get into one of these documents and review it with somebody, or for a tutorial like this, really, my body chemistry changes because of the outright unfairness and the willingness to just lie to your face and say, I do hereby swear to uphold the Constitution and laws of the United States to earn my paycheck. And they're lying right to you. So that's the status of appeals. You saw in these briefs, let's go to one of these pages, and you see that this was filed July 5th of 2017. So we're waiting on the deliberations in the 11th Circuit on this case and one on the 9th Circuit that's identical. The exchange of briefs took place by the end of July, and we're waiting for the courts to render their decisions. And then we're going to the Supreme Court because the record will remain barren of evidence that a tax is imposed. And all these statutes, they say, form the basis for their conclusion that you aren't entitled to further review. Those will be challenged as unconstitutional. Somewhere along the way, the record has to reflect the liability. They can't talk about it. So 2 cases on appeal. My next review, if I even do one, will be about the final order just issued in Kentucky or in Indiana in the tax court case, and that'll be probably a review of his petition to tax court, and maybe the exchange of briefing. It's going to be really worthless to review it. Why bother? Lost in tax court, but reserved for appeal. All these nice, juicy statutory issues. So he's reserved them for appeal. And we're on our way in Indiana, and that will be on the 7th Circuit. So now we have 9th, 11th, and 7th Circuits. The 9th and 11th are done. The 7th Circuit is about to commence, and we're going for it. I hope you've enjoyed this code breaker video to show you that, okay, for years I'm on conference calls, talk a good game, I got a website, and I say I got docket numbers. When it comes down to it, my maxim that you've heard in my conference calls that if you're going to litigate tax law, don't bother unless you're going all the way to the Supreme Court. Here I am living up to it. It's the job at hand. It's not a consideration. It's a reflex. So that's like Bruce Lee said, I do not fight. It fights. And so this is just a reflex action. We go to the Supreme Court. I know I'm right, the law is perfect, and I watch the government run from it. That says Supreme Court if I have to. Why? I'm an American.